Do we draft an arbitration clause in an agreement, or do we draft the whole arbitration agreement? What is the right approach? In this video, let's learn how to draft an arbitration agreement. But before that, what the heck is arbitration? Let's say there is A and there is B. Both wanted to enter into a contract to do a business. Let's suppose A is a good guy and B is not a good guy, and B breached the contract. What will A do here? In usual circumstance, A should go to a civil court, file a case against B and claim damages. Well, B is aware of it, that B breached the contract. B is also aware of the fact that court will take a lot of time to come to the conclusion, and by the time court comes to the conclusion, say 10 years, and fine Mr. B, well, B would think that it would be rather pleasant to pay fine 10 years later than going and obligating with the contract right now. We can see how A is suffering here, right? Now, business know this thing, like how it goes, and that's why the parties are allowed legally to go and create a private court arrangement, the arbitration, and appoint a private judge, the arbitrator. Now, this private court has no case pending before it, and the parties here would be its sole litigators, and consequently this private court arrangement will focus totally on these two parties. Resultantly, there will be quick resolution of the dispute. So this whole arrangement is arbitration, and the parties choosing the presiding officer would be the arbitrator. Now, the question comes whether the award passed by these arbitrators would be enforceable, and the answer is yes. The way courts, decrees, order, judgment are enforceable, in the same manner an arbitrator's award is enforceable. So wait a second, you are suggesting that anyone can go for arbitration, right? Not exactly. Not everyone can go for arbitration. Only the parties who have entered into a contract, and in the contract they have put the arbitration clause, or they have separately created an arbitration agreement in detail, only those parties can invoke arbitration in the case of dispute arising out of such contract. Here, party agrees that okay, if there is any dispute that arises between us out of this contract, say employment contract, B will work under A, and if there is any dispute between B and A, then they will go for arbitration, like that. So in this video, let's start drafting arbitration agreement. Firstly, we are going to put the title of this contract, the arbitration agreement. Second element is putting the parties details. Now, either you are an individual or you might be a company. So let's take this example only, where B was working for a company A, where B is an individual person and A is a company. So here, for the company, we are going to put the name of the company, the CIN number, the PAN number, and the registered office address. Now, as the second party B is an individual like you and me, we are going to put the name of such party. Then we are going to put either son of or daughter of his or her parents, then his PAN number, and then his place of residence. The question comes that why don't we just put the name and just leave it alone? The answer is that we do this because in order to identify such parties. Now we come to the recital clause. In recital clause, what we do is that we give a gist of the whole agreement. So for example, in this recital clause, we have briefed up the whole agreement into 3 pointers. Recital provision number 1, party B is the employee and party A is the employer. Provision number 2, there could be dispute during the course of employment. Recital provision number 3, if in the case dispute arises during the course of employment, party will not go for the court, but party will go for the arbitration. Did you see? We just briefed up the whole agreement into 3 pointers, and we already know what this agreement is all about. Now, let's draft the substantive part of this contract. Pointer number 1, claims. Now, we would want to see that what claims could go for arbitration. In this heading, we are going to define that what kind of dispute would be arbitrable. For example, in this agreement, we have stated that all the dispute arising out of such employment would be arbitrable. Pointer number 2 talks about the internal grievance procedure. So what I have put in this agreement is that in the case of any dispute arising out of this employment, party would directly not go for arbitration. Party will first go to the internal grievance procedure of the company. There will be internal procedure to settle the dispute amongst the parties. So the question comes that why am I putting this clause in this agreement? And the answer is to avoid the dispute. See, in the end of the day, arbitration is not free of cost. It does cost money. So it's better for the parties to settle the dispute and not burn holes in the pocket. Pointer number 3 talks about the arbitration. Sound very important, right? It is. In this provision, you state that in case the internal grievance procedure fails, in that situation, the party would go for arbitration. In this provision, you also decide the venue of the arbitration. Say Chennai, Delhi, Kolkata, Paris, wherever the parties want. Pointer number 4 is about arbitration procedure, and this is the beauty of arbitration. Here, unlike the litigation where the procedure is set in the law and you have to follow it, in arbitration the procedure is set by the parties to the contract. For example, party might choose not to go for physical arbitration, rather to go for virtual arbitration, say through Google Meet or WebEx. Did you see setting the procedure for the arbitration? So if we see our agreement, we would see that we have mentioned how we are going to initiate the arbitration through sending notice to the other party and other party responding to that notice, right? Then let later on we decide on how to choose the arbitrator, how parties are going to choose the arbitrator, and who is going to be the arbitrator, maybe a judge of the High Court. And finally, as a matter of practice, we also put forth that the arbitration award given by the arbitrator would be final and binding. Pointer number 5 talk about the arbitration cost. It states that each party would cover their part of expense in the arbitration procedure. Quite simple, right? And the next clause talks about that whatever cost or fine the arbitrator would impose upon one party, that one party would have the obligation to pay that sum. Pointer 6, governing laws. Here, party decide under which law they would want to get governed. So for example, if party A is from England and party B is from India, they enter into an agreement, the governing law could be English law. But for the sake of our example, where party B is in Indian and party A, which is a company, is also settled in India, here the governing law would be Indian laws. Pointer 7 to 12 is all about boilerplate clauses. So in my past videos as well, I've explained what boilerplate clauses are. Boilerplate clauses are those clauses which are present in almost all the contracts. They are common to almost all the contracts, but it does not mean that you go and copy paste it. Copy pasting boilerplate clauses to different agreements without looking into the fact could have catastrophic effect on the whole agreement. Parties could suffer undue losses. So if we see our agreement, we have put these clauses. Severability clause. According to this clause, if a portion of agreement get invalid, illegal, unenforceable, it does not mean that the whole agreement is unenforceable and illegal. The other part of the agreement would still be enforceable and very valid. Second, waiver clause. It states that in case of any breach of the contract, if the other party abstain from doing any action against the person who has breached the contract, so it does not mean that the victim party has waived off its rights. In case of future breaches, the other party would still have the right to go and sue the first party. Third one is kind of very special boilerplate clause that I have introduced for the very first time. No aggregate claim clause. So what I have stated here is that in case of any dispute, the other party is the only party who would go for arbitration. He is not going to invite anybody else. If there are other parties which are having conflict with the company, it does not mean that the party who is initiating the arbitration is going to invite all of such parties and aggregate the claim. He can't do that. Then we also put the interpretation clause. Many a time the agreement is interpreted to see the intent of the party. So through this clause, you just clarify your intention that boss, I want to go for arbitration, and in case you are interpreting this contract, we are totally up for arbitration. Fifth boilerplate clause, the amendment. According to this clause, unless each party sign on the paper that they are willing to amend a part or modify a part of the contract, any modification will not have any enforceability. And finally, the notice clause. According to this clause, the party decide in which manner they would want to serve the notice to the other party. And finally, the part comes where the parties sign the agreement in presence of the witnesses. And that's it. In case this video gave any value to you, please hit the like button, and in future if you would want to see more such content, hit the subscribe button. Thank you so much.